Most foreign companies treat debt recovery as something that starts after non-payment. In reality, it starts at contract signing. Your clauses determine whether you can act fast, prove your claim cleanly, and protect leverage when the counterparty delays. In Vietnam, enforceability is built, not assumed. In this video, we share practical clauses that strengthen payment discipline, reduce disputes, and expand recovery options if a breach happens. Clause 1. Clear payment terms and default triggers. Start with payment terms that leave no room for debate. Specify the exact amount, currency, bank details, invoice requirements, and due dates. Avoid vague lines like payment upon delivery without a defined timeframe. Then add default triggers. For example, non-payment after a stated grace period constitutes a breach, and the creditor may escalate. Also clarify partial payment allocation, interest first or principal first, and define what counts as receipt of payment. These details reduce ambiguity and make demand letters and filings far easier to support. Clause 2. Dispute resolution that is enforceable in Vietnam. Many contracts fail at the dispute clause. Choose a forum you can actually enforce against the debtor's assets. If assets are in Vietnam, Vietnamese courts or Vietnam-based arbitration, such as VIAC, is often more straightforward to enforce than a foreign court judgment, depending on the case. Whatever you choose, make it clear and exclusive: forum, seat, for arbitration, venue, governing law, and language. If you want an early settlement step, use a tiered clause with a strict timeline, so amicable negotiation does not become a delay tactic. Clause 3. Late payment interest and cost recovery language. Late payment interest is one of the strongest legal signals in a contract, when drafted carefully. Define how interest is calculated, when it starts, and how it is applied. This reduces disputes and supports a clean calculation if escalation is required. Where the contract is silent, statutory rules may still apply depending on the relationship and evidence, but relying on default rules increases uncertainty. If you want to recover costs caused by breach, such as collection expenses, storage, or third-party fees, use clear indemnity or cost recovery language, tied to documentary proof and subject to applicable law. Avoid vague, all legal fees promises that may be difficult to enforce as written. Clause 4. Security and credit enhancement. If the transaction value is meaningful, consider security from day one. Options include deposits, bank guarantees, standby letters of credit, parent company guarantees, and pledges or mortgages, properly documented and, where required, registered. Security does not guarantee full recovery, but it materially improves leverage and recovery prospects. Even a partial guarantee can change the debtor's risk calculation and make early settlement far more likely. Clause 5. Suspension, termination, and retention of control. Do not let continued performance become your own weakness. Include a right to suspend delivery or services if payment is overdue beyond a defined period. Add a clear termination right for repeated or material non-payment. For goods-based deals, consider clauses that protect control, such as retention of title or return rights where appropriate and workable. These clauses prevent a common scenario: the debtor keeps receiving value while the creditor keeps hoping payment will arrive later. Clause 6. Notice, service, and evidence rules. Many disputes are lost on notice and proof. Add a notice clause stating how notices must be sent, which addresses and emails are valid, when a notice is deemed received, and who may sign or acknowledge notices for each party. This sounds technical, but it is critical in Vietnam disputes, where proving notice and authority can shape the entire timeline. A strong notice clause turns your demand letter into a documented step, not an argument about delivery. Clause 7. Language, governing version, and interpretation. If the contract is bilingual, state clearly which language governs in case of discrepancy. Vietnam procedures commonly operate in Vietnamese, so ensure the Vietnamese text is legally accurate, not a literal translation. Consistent terminology across the contract, invoices, and delivery records reduces the debtor's ability to exploit interpretation gaps later. Good drafting is not about fancy words. it is about closing loopholes before they appear. A foreign exporter faced delayed payment from a Vietnam buyer. The contract included clear due dates, late payment interest, a strict notice clause, and a bank guarantee tied to specific payment milestones. When payments stalled, the creditor's demand letter was backed by clean calculations and enforceable contract mechanics. The debtor re-engaged quickly and the matter was resolved through a structured settlement without prolonged proceedings. Details adjusted for confidentiality. The clause design made the recovery path realistic from day one. A contract is only valuable if it can be enforced. If your business sells into Vietnam or contracts with Vietnamese partners, review your templates now, before the next unpaid invoice becomes a dispute. Let LTS Law help you upgrade your contracts for enforceability, evidence strength, and recovery leverage. Contact us at lts.com.vn for a contract audit or contract drafting support. In Vietnam, the strongest debt recovery strategy is the one you sign up front.